Okay, so I hope you're now seeing the Change Lab Collaboratory, and as you see, let's change this to May. May meeting, yay. So it's good to see all of you. It's a troubling time worldwide. Many of us are in complicated contexts, politically, personally, as we speak. So I'm particularly grateful that you all made it here today to be with us and to talk about the challenges of workers' rights enforcement, local, national, and global. And I'm very happy to have Janice Fine and Hana Shephard with us to present their forthcoming book, and Shelley and Guy to present our forthcoming article. Next time, we're going to meet in June 12th, and we're going to discuss Judy Fudge's book, Constructing Modern Slavery, Law, Capitalism, and Unfree Labor. Today, we're going to be, as I said, talking about enforcement. And I think the issue of enforcement, I'm really glad that Hana and Janice are here to talk to us about the enforcement innovations at the local level. I think so often when we talk about enforcement and the context that we study in this group, which is global value chains and transnational business, the details of enforcement remain very vague. And what I particularly appreciate about Janice and Hannah's project, both political project, policy project, and in this book, is really looking very closely at the mechanisms and enforcement at the ground level with worker participation and leadership, and at the local level, and also overcoming, structures that obstruct effective enforcement. So I don't want to take too much time. I want us to delve immediately in. I also really want to thank Fabiola Mieres from the ILO for coming and serving as a discussant. I don't want to take too much. I don't want to take too much time. So these are the speaker bios. Let me just say that Hana and Janice are both professors at Rutgers University. Both of them, Janice is a director of the Workplace Justice Lab at Rutgers, and Hana is a senior affiliated researcher with the Workplace Justice Lab. And they're gonna present their forthcoming book to us today. So we're gonna start with the two of you. So thank you very much again. The floor is yours.
Hana, you want me to say something, or are you gonna
go for it, please?
Okay. All right, so this book is really about a set of interlocking puzzles. And I'll just really briefly say what those puzzles are and then turn this over to Hana. So one is, as you know, the US has this level of federalism, which we mostly talk about as national, state, and local. And the action with labor standards enforcement has largely been at the federal level and at the state level. I won't bore you with the history where it actually starts at the local level, leads to state departments of labor being set up, and then we get federal, and then federal sets the pattern. And we argue historically that it's come, that there's this interesting development where it sort of then pops up at the local level. So what's our puzzle? First of all, we know that federalism scholars disagree about, whether federalism is good or bad, what it means for everything, including labor rights. But for our purposes, we really wanted, we said, hey, there's this emergence of this whole new layer of federalism on the scene that's focused on labor rights. What does that mean? What uses could it be put to? How effective could it be? And it gave us an opportunity to look at a layer of new agencies and understand under what circumstances do they arise, but then what does it matter where they end up in the bureaucracy, and then what are the forces inside bureaucracy that actually come to shape their approach to enforcement. So that's kind of what we're after. Do we argue that enforcement is fundamentally better at the local level? No. Are we making a case that local enforcement is the be all end all? No. We're asking questions about, kind of what is the potential? Why local? But mostly what we're after is what happened and what do we learn from that? So with that, I'll hand it over to Hana.
Thank you. Okay, so I'm going to try to give you a flavor of the whole book in 20 minutes, which is a little bit silly, but happy to talk a lot more about the details. So this is our book we call Cities at Work, Administration and Politics in Local Workplace Standards. Okay, so as we know, obviously the US labor enforcement regime is this archetypal neoliberal market economy, weak employment protections, flexible labor market, and really minimal role for the state employment regulation. And like Janice was pointing to, enforcement is fundamentally decentralized. It's very siloed in the sense that government agencies don't work with each other, geographically fragmented and very, very under-resourced. So we can look at, obviously the Federal Department of Labor, which has these regional offices, state departments of labor, and into that context, we're thinking about the growth of these municipal level employment protections in the US. So this is, starting in the last 25 years, right? There's been this move to pass law, raise the minimum wage, for example, pass paid sick leave laws. There's been a variety of really quite creative laws that have been passed at the local level. Something like 50 counties and cities have now minimum wage laws above the federal level. And with that has been the growth of not sort of matching exactly, but the growth of enforcement bodies that are located in local government. So that's really what we've been focusing on. So for the book, we're really interested in, how should we understand the promise of local enforcement weighted against the weaknesses? And so what we see empirically is that there's been a lot of legislative innovation with these laws. They're actually new, in addition to sort of raising the federal standards. One sort of hypothesis was that enforcement that is located at the local level will be much more in touch with, and responsive to the nature of the local labor market, that they'll be these government agencies will be more able to do outreach and develop really kind of close on the ground relationships with worker centers and advocates to be able to do this enforcement. One hypothesis also that it's easier to adopt new practices and generate kind of substantial organizational change at the local level compared to the state and federal levels. And similarly, that it might be easier to develop intragovernmental relationships. And I think we basically do think that these things are true compared to the state and federal level. So the question is what happens when you have these conditions? But as Janice sort of prefaced, there's plenty of weaknesses at the local level too. There's sort of issues of jurisdictional authority. In the US, municipal law is really legally vulnerable because it can be preempted by state laws, and is very frequently. Something like 26 states have laws preempting raising the minimum wage or paid sick leave. So this is like a strategy that's only available in a very select number of places. And then obviously there's sort of these laws are vulnerable in the sense that, and enforcement is vulnerable in the sense that international and national employees who are subject to the local laws have lots of resources to pour into challenging the laws or their enforcement. So those are kind of some of the big challenges. So we studied for the book, we studied 4 municipal labor standards enforcement offices in different cities. So the first one was in San Francisco, started in 2001. Seattle followed in 2015, so a substantial gap in the next sort of large, well-resourced office. LA was in 2016, and New York City was also in 2016. So really different, different cities, different kinds of like political institutions. We're trying to ask really, how do they do enforcement? They have, and sort of what are the challenges in the way. So this was work that grew out of Janice's sort of longstanding relationships with worker centers in each of these cities. We started the field work for this around 2017, building on what Janice had learned in sort of a decade prior to that. And we did a lot of interviews with staff, both in the offices and in other local government bodies. We talked to sort of the, people who were central to the unions and the worker centers and community organizations that sort of built the coalitions to get these laws passed. We tried to talk to the employer side as much as we could. And then we used sort of documents and archives to also try to sort of build a picture of like both the history of each of these offices, and then what were they actually doing on the ground, and then sort of tracing that for a couple of years to look at like what were the practices that they were engaging in for enforcement. So these cities, obviously, they vary in a number of dimensions. Obviously, size is really different between the San Francisco, Seattle, and LA, New York, comparisons. There's a lot of variation in the nature of employer power in those cities. There's some, similarities in sort of some of the politics, but a lot of the political institutions vary. But we are kind of identifying that there's some key pieces in all of the 4 cities that co-occurred. So in each of these 4 cities, they had almost very, very similar degree of legal enforcement authority. So there's not a lot of variation in sort of how much, what legal tools each of them have at their disposal for doing enforcement. They're all supported by strong worker and labor organizations. They all had a very supportive city council majority, a supermajority to support these laws. And then importantly, like they're all substantially funded. And that's one thing that varies a lot across the country. There's now something like 26 cities with labor enforcement agencies, but that often looks like one person. And this is a different category of funding. So really what we're interested in is how should we understand this tension between the kind of enforcement that gets done in each of these cities, and really, do they do the kind of enforcement that has the possibility of disrupting sort of very fundamental, assumptions about the relative power of employers and employees, or are they just kind of trying to provide guardrails against the very worst of labor violations? And so that's really, how we think about, and Janice's previous work and focus on strategic enforcement, right, is really kind of thinking about, what is the end goal of the way that they're doing enforcement? They're just trying to, I do think that there's this really, we're fundamentally interested in this, like, can this kind of enforcement, especially at the local level, move towards economic justice, and what gets in the way of doing that? Okay, so just to give you a sense, and this is really kind of what we're trying to explain in the book, is how do we get these quite distinct approaches to enforcement in these 4 cities. So in San Francisco, we see that the investigators and the managers really think of themselves as like, we're enforcement agents. We kind of do the meat and potatoes kinds of complaint-based enforcement, and we stay in our lane. In Seattle, they are really kind of have a pro-worker ethic through, and the way they justify that is through that these laws give workers rights, and we're here to implement the law. So that's a different kind of sort of approach. In Los Angeles, really distinctly, they say we walk the tightrope between employers and workers. So they have this kind of neutral arbiter approach to enforcement. And in New York, they are like sort of full-throated, endorse, we are here for the workers, like, and their practices sort of align with this. So these are kind of the ethos of each city that we observed. And it's aligned with a number of specific enforcement practices, and you can actually kind of see the implications of these different kinds of approaches just by looking at the number of complaints that they receive per 100,000 residents, and we can see that LA is far below each of the other offices. Which is, of course, like really indicative because LA is considered the wage theft capital of the US for a variety of reasons. So the kind of, we can characterize their ethos and also kind of, get very granular about how do they specifically approach their enforcement, and what practices do they use and what practices do they not use. So that's really kind of the puzzle of the book, is trying to understand how do we explain these very different approaches. Hila, I forgot to look at what time I started. So if you just flag me whenever you need to.
I will.
Okay,
You're
thank
good.
you. Okay. Okay, so our book argument, I'll just sort of lay out here, and then I'll try to paint some more of the details with whatever time we have left. But the idea is that, obviously kind of a really robust enforcement of employment laws. And in this case, we're really interested in like how expansive and how oriented towards creative solutions are these enforcement offices. How much are they sort of bound to previous ways of doing enforcement, receiving complaints, trying to do investigations, sort of plodding along, versus like how broadly are they thinking about how do they do enforcement? That's really the kind of the this key distinction or spectrum that we're interested in. So we clearly see that the robust enforcement that's more creative and that's more pro-worker is challenged by both the political power of capital, and the part that we really want to emphasize and spend a lot of time on in the book is actually all these ways of accounts of how government should do its job that are really, really pervasive in each of these 4 cities, city government, and we call these the administrative logic. So those 2 things are obviously working against this very expansive kind of creative enforcement. These are kind of the administrative logics that we identify as really important, is basically privileging following the rules as opposed to like achieving substantive outcomes as a kind of principle of governance. And this is, we're happy to talk a lot more about that. This sort of legal caution and really narrow legal interpretations that are driven a lot, particularly by the city, sort of city attorney's offices or legal departments, which have a lot of control over what happens in these offices. And then these kind of rules and about a bureaucratic accountability, sort of chain of command, not messing anything up as a organizing principle of how sort of the bureaucratic logic in each of these cities. And so both of these things matter, obviously. What we sort of chart is that what's really interesting is that the political power of capital in these cities kind of sets these initial organizational conditions for the offices. So what do we mean by that? The politics is really important in shaping what parent agency each of these enforcement offices get situated in. It obviously shapes which people are the first leaders, and it has a role in shaping how do these offices do staffing. And I'll sort of give you some examples of what each of these look like. And then what we find is that each of these kind of initial conditions that are the product of the politics provides these resources that each of these enforcement offices have to kind of both understand and navigate those administrative logics that are working against expansive enforcement. So this is sort of what legal authority they have, their experience and skills, their vision and narratives about the offices, and the set of relationships they have. And so in places like New York, they had, even though their sort of initial conditions were not favorable, it gave rise to a set of resources that allowed them to be super creative and expansive thinking compared to a place like LA. I'm going to skip sort of there's lots of, as you might imagine, examples about kind of the political power of capital in these cities, and just give you sort of a flavor of what the administrative kind of initial conditions look like, comparing Los Angeles and New York. So the Los Angeles enforcement office got put in a parent agency in local government, which was the Bureau of Contract Administration. And that office had a very, like the kind of guiding principle was, following the rules around contracts. And so the parent agency ethos was exactly sort of literally, we had someone tell us that one of the gifts to the city of our office, the BCA, is walking the tightrope between business and labor well. And so if you get an enforcement agency that gets put into that environment where that is the guiding principle, then obviously kind of thinking about enforcement as like kind of trying to balance between the needs of employers and employees was very, very pervasive. And so that was really important to setting the first, setting up initial practices, setting up like what are the guiding principles of the office, et cetera. In contrast, in New York, the office was put into the Department of Consumer Affairs, which was a really interesting choice. It was also deeply politically the result of political pushback against the paid sick leave law, which labor and worker organizations wanted to put in the Department of Health, and employers really did not want to have it in as part of the Department of Health, because they saw the Department of Health as a very robust enforcement regulatory agency. So it got put in Consumer Affairs, which was sort of, initially charged with like going door to door in shops and sort of making sure people weren't getting cheated in sort of how much fish that they got for, what they were paying per pound. So that's a really different ethos. And there was a complicated sort of backstory about trying to neuter, in the recent history, trying to neuter the Department of Consumer Affairs by reducing how many fines that they were levying against small businesses to be able to make a case about the importance of small businesses to the economic life of the cities. So those are just some examples of like these political fights that gave rise to specific organizational conditions that each enforcement office got put in. So with those sort of political fights and the placement of the parent agency came a number of like initial practices and resources that the enforcement offices also had at their disposal. So, for instance, the nature of the relationship with the mayor in Los Angeles meant that the Office of Wage Standards, the enforcement office, staff and leaders were waiting for some direction from the city council and the mayor's office regarding enforcement practices and outreach materials. So they were really in a sort of, wait and see position, worried about what kind of feedback they'd get from political leaders. In New York, one of the real challenges with being put in the Department of Consumer Affairs is that it was a very large agency. And as a manager told us, right, the Department of Consumer Affairs does 800 different things and all of them are underfunded. So they're basically kind of, subject to resource shortages as a function of getting put in this particular kind of parent agency. And so one of the other kind of key, what our sort of key analytical move that we're trying to make in the book is to show how these initial conditions and sort of the administrative procedures of each of the city produce these really different sets of resources that the offices had. So one of the key things about LA is that the civil service hiring rules meant that the specifics of the rules and the specifics of what kind of civil service positions they had available for the enforcement office meant that there was massive amounts of staff turnover, and actually a lot of the investigators had no substantive experience or interest in labor standards enforcement. So that was obviously created a really different set of enforcement capacities than in different places. Another key part of the story of LA is that they did not have their own internal legal expertise. So in contrast to particularly Seattle and New York, where the leaders were lawyers and a lot of the managers that they hired were lawyers and had legal experience. In LA, they had no one with legal experience and expertise, and they had a very tight relationship that was sort of mandated with one deputy city attorney who gave them extremely conservative legal advice. And so this was the quote from this one deputy city attorney. "I'm not a policymaker, but personally, I think you have to balance what employers have to endure to be in the city versus employees' rights. So I think we've gone as far as we can with the legislative powers given to us." And we have lots and lots of examples of how, and not only so she says we've gone as far with the powers given to us, but they over and over again didn't use many of the forms of legal authority they had at their discretion in the practice of enforcement. So it's an illustrative quote, but it's totally wrong because they didn't even use what they had.
Hana?
Yes.
We kind of need to start wrapping up.
Okay, thank you. Great, thank you. Okay, so this is sort of what we're tracing, is that basically there's sort of these different kinds of resources that each of the offices have that are internal and a product of the politics. And these are the things that allowed them to navigate these kind of challenges or not. So as you can see, like in LA, they both don't have the kind of symbolic resources for very pro-worker orientation towards enforcement. They didn't have internal legal expertise, and they didn't have managers who cared about the substantive outcomes of enforcement. And so we get this a kind of enforcement that's really much less robust and strong. There's a lot of nuances in the other cities, but we kind of see the patterns that emerge in terms of how robust their enforcement is as a product of kind of what they got and how they were able to kind of either creatively challenge the ways of thinking about government that pushed back on expansive enforcement or not. So I'll leave it there, but we're very happy to talk about sort of the implications and what it all means. Thank you.
Thank you so much, Hana and Janice, for this very rich presentation. I'm sure there are lots of questions, but let's first hear Shelley and Guy, actually in the opposite order, Guy and Shelley, and then Fabiola, and then we'll open it up for discussion. So everybody, if you have questions, you can either start typing them in the chat, or we'll raise hands and discuss in person at the end of the next presentation. So now we're going to hear from Guy and Shelley, who are going to be presenting a paper the three of us co-authored. So Guy is a professor of law at Tel Aviv University and at the Department of Labor Studies in the Faculty of Social Sciences. And Shelley is a professor of law at RMIT University, and you can see both of them have done many things in this field. For lack of time, I'm not going to read all of this, but my very accomplished co-authors are going now to present our paper about workers' rights enforcement in global value chains. So Guy, are you going to share screen with us?
It's already shared.
I think I did share the screen. I didn't?
Yeah, looks
Yeah.
good.
Wonderful.
Okay.
Okay, great.
It's made with Gamma.
You know I'm an
Hila,
addict of AI.
Hila, aren't you presenting with us? Because suddenly I'm worried that maybe I skipped something.
No, Shelley is going to present. So Shelley is presenting the second half and you're presenting the first half.
Okay, I think I'm presenting the first third, but maybe we'll have a gap in the
That's
middle.
fine.
And
And
then we
Shelley
can
gets
sing
2/3.
we can do a sing-along or something, you know, or
No gap, no gap.
No
You
gap?
can see we coordinated this really well before coming
well,
on.
there is one gap, and that's the enforcement gap, right?
Yeah.
Okay. So, the only thing is that my notes have suddenly disappeared. So I'll try to do this without my notes. And first of all, to tie it to the previous paper, which I really enjoyed, and I think that if we're talking about globalism, then really both papers are departing from the national level, where it's usually the usual place where we look at enforcement. And while Janice and Hana are going down to the city level, then we're going up to the transnational level. And I think that in both of these quests, then there are a whole lot of recurring questions. So I think that this is an interesting way to tie the two things. I think with this audience, we can skip the issue of what are global value chains and why they are a problem. And as we
Yes.
see that there's a growing transnational governance system with a whole lot of instruments and a whole lot of pieces inside, then always the recurring message is that enforcement remains a problem. And I think it is a problem of intersectionality, because we see here on the one hand, the general problems that we have in domestic enforcement challenges, and that's featured work, fragmented work, multiple employers, growing inequality, and more workers on the lower end of the labor market with low levels of legal consciousness, and difficulties in how to bring forward their grievances or stand up for their rights. On the other hand, we have here the problem of transnationalism, which cuts across jurisdictions. And I think that the intersectionality of these two creates a totally different problem that we want to consider. Now, if you look at the general system of transnational instruments, then with each and every one of them, there is a problem of enforcement. So clearly, if we're talking about CSR, corporate social responsibility, or for the most part, international framework agreements, then they are considered to be soft law, which is kind of explicitly defined as being non-enforceable in law. If we look at international conventions, there are some enforcement mechanisms, but they're not utilized. If we look at trade agreements as a way of governance, then that's considered to be the hard bite within the transnational governance, but they are not used often enough, and they are always bound by political constraints. And as we go down the list, we
Guy,
see
we
that
can't see the next slide. I don't know if you wanted to move
I'm still in
slides,
the
but-
problem weak enforcement in GVCs. That's what you're
Oh,
saying?
okay, sorry. I thought you were already
Yeah.
going down our table.
No,
Sorry, I'm not gonna interfere
I only
anymore.
have 2
Go
slides
ahead.
in my short exposition. So
Sorry.
I'm there. And I lost my note, so I'm kind of like trying to recover whatever I have in my mind. I hope it resembles what we have in the paper. And so where was I? Okay, so with all of these fragile or incomplete or instruments that are faulty, there are also ideas out there that seem to have better traction, and we're thinking about worker-driven social responsibility, which encompasses a few examples that are very different one from the other, but they give some idea about what would better enforcement look like. And we also want to consider that with each and every faulty instrument that we have in the transnational web, then there are also some improvements that are made despite the faults. So what we're doing in this paper is we're trying to actually think, what are we talking about when we're talking about improving enforcement? And this requires 3 steps. The first is to try and define what do we think about when we think about enforcement, and that's what I'll do. Second is to test this theoretical framework on existing instruments in the transnational system. And thirdly, consider how do we conceive the next step in terms of improving enforcement, but not necessarily in terms of the political economy of how do we get from here to there and whether it's politically feasible. And I think that it's important to emphasize that the difficulty of enforcement within the global value chain system and within the global labor market is not just some kind of a coincidental side effect of the development of the global economy. It is the feature of the global economy where the global value chains and other forms of transnational activity were designed on the premises of legal building blocks or modules, as Katharina Pister calls them, that intentionally try to remove those at the upper nodes of the global value chains from taking responsibility to violations of labor rights down the value chain. So this is an intentional problem, and therefore the political economy of how we get from here to there is not that easy because it actually goes against all the hopes that were built up legally and socially and economically with the design of the global value chains. So now I'm moving to the next slide, and that's talking a little bit about what are we thinking about when we're thinking about enforcement. So usually when we think about enforcement, we think that there's a violation of workers' rights at the shop floor level, and the worker can bring a lawsuit to the court or can complain to some kind of a public administrative body, or the public administrative body or inspectors have their own schedule of monitoring employers and workplaces for violations of workers' rights. So it's quite an easy framing that basically a lot of the literature of both enforcement, deterrence, and compliance is built around. And we think that thinking about it that simply does not really cover the various problems that we see at the transnational level, which include, first of all, the distance, and this is a legal distance and a physical distance. It also includes the fragmentation of the corporation. It also includes the low level of legal consciousness down the value chain and the fluidity of the transnational instruments. So when we think about all of this, we want to kind of stretch the idea of enforcement in several ways. And we have here 6 building blocks of what would be effective enforcement. So first of all, we need to think about clear prescription of rights. And we usually have a separation between what are the employment standards and the enforcement issue, but they are tied together. If we have an transnational instrument where the only employment standard is that we subscribe to the fundamental labor principles of the ILO, that's not enough in order to assign clear sense of rights and obligations to the parties in the employment relationship. We want to see a very clear prescription of rights and something that can be operationalized. And this, for example, we will see, I think, the more detailed list of norms we will see in the soft law, in the corporate social responsibility, in labor codes documents that perhaps were developed in a very explicit and very specific way because they're a soft law. But that is one contribution that they bring to the scene. A second component is the idea of information. And here we have 4 components of information. One is the information should go from the upper, what we call downstreaming, is to have information flow from the upper nodes of the global value chain all the way down to the workers. And that's explaining to workers what are their rights, acknowledging them about their rights, telling them how they can complain about the violation of rights. A second component is the upstreaming. And that's bringing information about violation of rights all the way from the shop floor, down in the global south, up to the headquarters, up in the global north. A third component is side streaming, and that's bringing information about violation of rights to consumers, to municipalities, to other staff, to financial institutions, all those who are supposed to supervise and monitor compliance with rights. And if I can bring an example, for example, in the Cambodia Better Factories design, once they decided not to publish the name of contractors that are violating rights, then the efficacy of the program went down. So we want to allow information to go to the sides as well. And the fourth component is kind of learning loops. Is there a mechanism within the whole governance system that actually looks at the way that complaints are being filed, how they're being handled, and what should be improved systematically and structurally for the future? A third is safe and accessible, and I can also tie it with independent and competent. So we're looking at features of a good grievance system. So safe and accessible, workers should know that they're not going to be harmed in any way for filing complaints. So that may be whistleblower protection, which is a problem that we don't know how to address seriously in domestic labor law. So it's clearly even way more difficult when we're dealing with global value chains, but we need to create some kind of a safe space for filing a complaint. And we need that the authority who receives this complaint is independent and competent. And that's not obvious either, because it cannot be an agency that is motivated by the same interests that are out there to pressure down the compliance with workers' rights. So if the state has an interest not to highlight workers' grievances in order to attract capital into that state, then that state will not be necessarily independent and competent to do that. A fifth component is we're talking about a system that is accessible, that is timely. And here we want to distinguish between daily grievances at the workplace and issues that are more systematic. So how do we address grievances at the workplace on a day-to-day basis immediately? and how do we deal with a compilation of problems and bring them up the value chain. And of course, the borderlines here are not clear. So if we have one instance of wage theft, then that's a daily grievance. If there are many instances of wage theft, then that becomes a systemic problem that has to be brought up. And we probably want to think about different mechanisms for different types of problems and some way to sort out between them. And of course, that's tied to the learning loops of how do we learn, when does an individual problem becomes a serious collective problem. And finally, we're talking about meaningful redress and enforceability. And here again, we have a few components. So first of all, we want to have some kind of financial aid to those whose rights were violated, and that's quite obvious. And in addition to the financial aid and the compensation part, we also want to think about qualitative issues such as an apology or acknowledgement of doing fault. A second thing that we want to think about is how to create, is the idea of prevention and how to prevent future instances of the same problem. A third component would be of how to expressively illustrate the responsibility of the agents up the global value chain towards the rights of those workers. And I think that these are three separate components, and not necessarily we can have within the same governance instrument a good answer to all of them. So again, the worker-driven social responsibility tried to have a few levels or a few different avenues of meaningful redress, but that's something that we want to consider, whether it's possible to extrapolate from these examples and create something that is more sustainable and can be spread all over. So I think this is the general framework. With all of these components, collective representation of workers, whether it is by trade union or whether it's by INGOs or whether it is by communities or some other form of voice, is essential. It's essential for defining the norms to begin with. It's essential for information, for the safe space that we want to give workers. It's for carrying out the dispute resolution and for being out there to make sure that redress and enforceability are indeed meaningful. So this is the framework, and I hand it over to Shelley from here.
Thanks, Guy. So having kind of tried to disaggregate and pick apart what meaningful enforcement entails, we then applied it to a range of instruments to carry out this comparison of the strengths and weaknesses of various types of instruments that attempt in some way to regulate labor in global value chains. And the conclusion that we came to is that really there's a persistent enforcement gap across all governance models. And what we see here is quite a kind of scattered, decentralized, experimental model of enforcement. So we'll all be very familiar with, I think, each of these categories, and I'm not going to go into them in detail, just to say briefly that soft law instruments like corporate codes and international guidelines set really important normative benchmarks. They have the benefit of being either company specific or industry specific, but they fall short of actual enforcement. Mandatory human rights due diligence laws introduce binding obligations, but when we look really closely at how they work, they do remain largely process-based, and they often exclude workers explicitly from meaningful participation and remedy. Transnational litigation, which I think, lawyers often think, well, if we just make it, if we just include litigation, that's going to solve the enforcement problem. When we look at Guy and Judy's really fine-grained analysis of cases entailing labor rights in global value chains, they find that jurisdictional barriers, high costs, lengthy legal processes really make those processes largely inaccessible for workers. Trade-based mechanisms obviously have the benefit of offering very strong economic tools, but they tend to prioritize state interests and extreme violations instead of dealing with everyday labor violations. Worker-driven models, I think, in our kind of world are often held up as the holy grail of enforcement. And, we've had papers on different worker-driven models in this series, and they certainly do seem to offer the most effective and responsive enforcement with their continuous oversight, their real-time grievance mechanisms, and the fact that they also entail economic consequences, but they lack institutional power. They don't bring in the state, they don't have state backing, and there are all kinds of problems with scalability that have been discussed here already. So what that means is no single model covers all of the 6 building blocks that we examine. Can you go to the next slide, Guy? Or who has control over it? You have control, don't you, Guy? Yeah. So none of these address all of the 6 building blocks which we identified. But what they do show is different strengths and weaknesses. They show they show a kind of an array of methods of addressing enforcement. So next slide.
Next
Guy.
slide.
Yeah, thank you. So recognizing this problem of this enforcement gap, and in particular, the problem of an enforcement gap which would empower workers, the International Lawyers Assisting Workers, which is a network of union lawyers and firms and so forth, which and academics, which represent unions and worker organizations, commissioned Ingrid Landau and I to draft a text that would form the basis of an ILO convention on decent work in global supply chains that they would argue for at the ILO. And the idea was, what we were told was really just to go for it. Like, don't anticipate what employers will say. Don't be concerned about any kind of likely concerns and limitations. Just draft a kind of a blue sky option. And we were really lucky to have a very esteemed advisory panel as well. I provided the QR code so that you can all very easily access the draft online. And our hope really was that, because there's very low likelihood that this will even get anywhere within the ILO, that it would instead kind of provide a basis for discussion, that aspects of it might find their way into other instruments in a spirit of experimentation, that we understand those decentered kind of models that we've already examined to sit within. So the features that we attempted, thanks, Guy, you anticipated my next desire. The features that we attempted to build in, which we don't see in other mechanisms, included the facilitation of cross-border social dialogue and bargaining. So what we tried to do was create a framework that would support bargaining across borders and within a global value chain. So we might think of, for example, the institutionalization of global framework agreements that would actually, instead of the way that they operate at the moment, which is normally kind of a deed between a large brand and a global union. Instead, it might be an agreement between unions throughout a particular value chain and the global union and a brand and possibly suppliers within a particular value chain. And the idea is that there would be the scaffolding to facilitate legally binding and enforceable cross-border agreements, with then monitoring, mediation and dispute settlement provided by the ILO. So expanding their scope and expanding the powers of the ILO to be able to kind of to provide that mediation and arbitration. With the establishment of arbitration panels made up of expert arbitrators from across the world. So that's, one aspect of it, which we think is sorely lacking. But although this looks in some ways like a highly centralized system, our hope is that it would instead support the kind of decentralized experimentation that all collective bargaining does in a way, because every collective bargaining agreement, is different. It's able to respond to the dynamics of the, particular industry or the particular parties that are involved in it. And therefore, hopefully bring in some of the kind of responsive elements that we see in the previous mechanisms that we looked at. Guy, can you take me to the next slide? And then a further aspect is a system of enforceable, of state level enforcement. So if we imagine an agreement involving national level unions, a global union federation, and then on the other hand, this is just to kind of show you pictorially, and the brand, the ILO provides this forum. And then at a state level, also, where there's a dispute at a kind of lower level, there would be the possibility of adjudication that fits within whatever style that state uses. So, for example, we see in the French vigilance law, it's mainly a judicial system. When we see the German system for the German supply chain due diligence law, that's there's a competent authority that mediates or that examines, investigates, and hopefully enforces there. But the system that we designed would accommodate different national systems. Next slide, Guy. So here we see this kind of the options for enforcement. So, for example, there might be a worker or union complaint. It would go to investigation by a competent authority, and which might be a labor inspectorate, or it might be some other body agency, depending on who's kind of has responsibility. So, for example, in Germany, that hasn't been sitting with the labor inspectorate. And then there are options. There might be the option of going straight to a written confirmation. It might go straight to a determination by the competent authority. One of the things that we really want to see is far greater cooperation between competent authorities, such an important aspect of dealing with cross-border breaches in labour rights. And then the possibility of it there being orders for cessation, remediation, and different kinds of penalties, or in systems like the French one, it might go straight to the judiciary, or then it might be appealed to the judiciary. So again, trying to encompass the range of processes that we see around labour rights breaches, but accounting for the cross-border nature of global value chains and the dynamics that lead to labour breaches, which are often caused or at least influenced by parties who are outside the state where the breach occurs. Next slide. So given the very, very remote chance that this model would be implemented, well, where does that leave us? And currently, we live in an era of regulatory pluralism and experimentation, where we have these kind of geographically disparate, scattered mechanisms which we examined with regards to labour regulation in GBCs. But is it really an alternative to centralised enforcement? Is where we where we ended up in this paper. Obviously, one of the benefits of this kind of range of mechanisms that we see is that they do offer adaptability, and there is a form of network governance in some ways where different problems are being dealt with by different mechanisms currently, which, as we saw, have very varied strengths and weaknesses in terms of the way that they conduct enforcement. But the problem is that this system is entirely uncoordinated, and it does leave really significant gaps, which mean that enforcement is lacking. So our hope is that the proposed text for an ILO convention solves some of these problems of systematic global application, but at the same time does allow for experimentation and learning that can be shared across competent authorities. Of course, the problem is that when you have a system which could potentially lead to enforcement of that type, it's more likely to be opposed by employers and states. So where we wanted to leave you is just to say that the 6 building blocks framework proposed here invites deeper exploration of how enforcement mechanisms can be recalibrated, how they can be interconnected and adapted to cover all stages of the enforcement process. And as we're thinking about new models, as we're dreaming up new options, to think about whether they really do include all of these building blocks for enforcement. Thank you.
Thank you very much, Shelley. Without further ado, in hope that we'll have a little bit of time, let me introduce Fabiola Mieres from the ILO. She is a researcher at the Effective Labor Market Institutions team at the ILO Research Department, and one of her focus areas is perfect for us today because she's thinking about the conceptual and practical analysis of enforcement and compliance approaches within labor protection. Fabiola, thank you so much for being with us, and the floor is yours.
Thank you. Thank you, Hila, for inviting me. And thank you to the all organizers. And I prepared some notes, but after these rich presentations, I think I will just skip my notes or use them as background because there's so much to discuss, and I would like to give the floor also to the other participants because I'm sure there are a lot of questions. The first thing I want to say is that I'm really, really happy that this session is devoted to such a complex and difficult issue as the authors have very well laid out. And in the ILO, we are particularly interested in this because we have been putting norms out there in the world for more than 100 years. But then we realize that there's little information of what happens after that, what happens with its compliance and therefore its enforcement. So there's still a big knowledge gap in terms of political economies, industrial relation systems, and the levels that we'll address today. So I'm really, really happy, and I hope a lot of people in this group shift the research projects also to look at the analytical focus of enforcement and how it plays out in the different sectors, in their economies, and different development levels. So also thank you for giving me the opportunity to read the introduction of the book, Hana and Janice, which I look forward to reading the whole book now. So I have a few questions, but probably they're answered in other parts of the book. And Hila, Guy, and Shelley, your paper is super rich and comprehensive. And I was at some point reading, thinking, this could be turned into some form of guide or something that can actually help constituents when they think about improving enforcement in other dimensions of the work, because it covers a lot. So different models have been presented today, but one of the things that, as Guy said, is that normally when we think about this, we're assuming the territorial, natural nation states as the container of these labor laws and the potentials for allowing us to develop mechanisms. And that has given place to a rich literature on models of compliance and enforcement that has looked at labor inspectors. We haven't named them yet here, which I think it's a very important actor in this space. But here actually we're moving a little bit beyond, which is great, looking at two different levels. The local, which has had a big turn in governance studies when looking at cities. Another area of my work is migration. So there's a lot of work being done on the role of cities in migration governance and how that can transform even potential national legislation. So I have a few questions around that. And of course, then the problematization of global supply chains, a classic topic that keeps us awake to most of us every day, I would dare say. So one particular thing I would like to highlight from Hannah's Janice introductory chapter, and I think it pertains to all of us in thinking, is I really liked where they highlighted how different groups define the problems. Because how different groups define the problems of non-compliance or non-enforcement in this case, these are the solutions that are being presented and decides to address the problem. So this leads us to the logics. And one of the things that they raise in the introductory chapter, which I think applies to most contexts, and this is the reality of the global economy, as Guy was saying, is that in the nature of the capitalist labor relations and democracies that we have, business interests are seen as the interests of the community because they create economic prosperity, because to the citizens, because they give jobs. So the government must support this by either nurturing this interest, which at times includes keeping regulations at a minimum, and that might include keeping efforts of enforcement at a minimum. So I think these ideas, even though they might sound a bit theoretical, they're important to give further thought, because the way they apply at the different levels are challenging our models of enforcement per se, and the nature of the state and the capacity of the regulated state. So I think here also I would like to maybe understand a little bit more what Guy meant when you have to move beyond the political economy approach, because for me, a political economy approach is exactly what remains crucial to unpack these power dynamics. We cannot simply understand enforcement as a technocratic exercise, and especially now with the advent of AI and how it's going to solve all our problems and how we're going to do this. So I think we need to really, depending on how we understand a political economy approach, is key to understand how these actors are operating in the space. So at the ILO, in this project I'm working on, we have developed our own kind of global political economy perspective to this, because a lot of the countries that we work with are middle income or low income countries, and they are really subject to the power dynamics of international trade, investment. So a lot of the enforcement efforts are sometimes put not as a priority. That's why I say this is important. So I have a few questions in the spirit of kicking out the conversation, and some go to first Hana and Janice. So you talked about, I would like to hear a little bit more about this logic of the complaint-based system, even though if a lot of the literature has pointed out the problems of the complaint-based system. For the things that we know, the workers lack the agency to use the systems, to complain. If they're migrant workers, it's even more difficult. How about more proactive forms of enforcement in the cases that you have studied? And also, if you can say a little bit about the role of the local labor inspectors. And then I also understood from your comparative setup that you focused mostly on standards enforcement offices, but have you had a chance to look at the motivations of employers to comply with these norms at the local level voluntarily, or what interactions they had with the local enforcers. And then another question, which actually, sorry if it's an incorrect question, but I did see changes in a context where I studied a city in South America, in Chile, at the city level, in the governance of migration. It managed to change some of the national policies. So there were feedback loops there, or things that were happening at the local to the national. Is that the case for your cases? Or maybe I'm hoping too much. So actually the relationship with the federal at this state. And the last question, it comes to the issue of resources, which I think is important to think in terms of sustainability. How are we going to sustain the advances in your cases? But not just looking at the financial resources, the money that should be there. I like your separation of symbolic. So what's the role of the symbolic resources, especially now in a context where all of our values are being challenged, what's going on in the United States? And I wonder if you can have some early reflections on the current context of the US for your findings. And then Hila and Guy, I would go very quickly. I thank you for your paper, because I think it organizes a lot of the literature around the transnational governance and the problems that we have. I mean, you bring this difficult aspect of enforcement to it has been overlooked sometimes, or it's an afterthought. I was wondering in your building blocks, if you have considered including some notion or some idea of resources. I know you're thinking transnationally, but we need resources to execute these mechanisms. How could that fit in there, right? And also I'm wondering if you have looked at context of cross-border inspections, like in the EU, for instance, in the European Union. Is there anything we can learn from there? For instance, the role of the European Labour Authority. I know they deal mostly with mobility in the EU context, but a lot of these workers, the posted workers as well, are part of global supply chains. So I wonder if you had a chance to reflect on that. And my final comments are questions basically to the whole audience, hopefully to trigger discussion, is so I think enforcement seems to me, unfortunately, still pretty much, even though I think transnationally, but it seems to me a very territorialized project, right? Where the nation state has an important role. So that limits our thinking in terms of transnational approaches. How can we deal with that? And whether is it possible that these transnational governance structures that have been reviewed by the three authors can help us change local practices on enforcement? Is that something that is possible? And one thing here, I was thinking that really struck me from my own studies of the Fair Food Program is this idea of market consequences. How they manage to make growers abide by it, and they really have teeth. One of the strengths that you also highlight in your paper. But is there a way to think of extending this to other mechanisms in the context of this capitalist democracies that we're all living and all this backlash? So I was wondering how, because I think there's an avenue to really enhance the enforcement side. So thank you for these reflections, and look forward to your reactions.
Thank you very, very much, Fabiola. You've put a lot on the table, and we have a relatively limited time. So maybe let's take quick responses from Janice and Hana, and then from Shelley and Guy, and leave maybe 5 minutes for some more comments. So Janice and Hana, do you want to?
Fortunately, we'll speak quickly, or I speak quickly. Okay, so Fabiola, thank you for those great questions. And one of the reasons why Fabiola and I connect is because neither of us are lawyers in this group. Okay, so the logic of complaint-based systems. So Fabiola, that's what was really interesting, right? Is that I've worked with these agencies almost since their inception. I know them all. You know, I've been in conversation with them. In some cases, we've been really involved in them starting and, you know, at the Workplace Justice Lab. So they're all familiar with the building blocks of strategic enforcement. They all know that complaint-based enforcement has huge limits for the reasons you said, that not every worker is comfortable coming forward in terms of their, you know, particularly now, obviously, but always, their precarious positions because of their status, and for other reasons as well, but you know, their status. You know, just so you know, like what we find is also non-high school grads in addition to people of color and foreign-born workers, non-high school grads and seniors have very higher levels of wage theft. Okay, so they know strategic enforcement tools, which I'll just say very quickly. You have to have triage. You can't, do first in, first out. You have to, because you have to have the resources, right, to focus the problem. You have to target the high violation sectors that may not be getting a lot of complaints. You have to think differently about investigation and about how you involve civil society actors that have deep trust with organizations in the process, and also understanding all kinds of things about how these actors operate and what that should mean around, how you actually conduct investigations. And then how you think about rounding back always to the workers and the worker organizations to double check what they're hearing from employers, and then ultimately naming and shaming and how you think about deterrence and all that stuff. Okay, so they know that. The question is, do they do it? And why or why not do they engage in what we now know are a series of tools that we have good reason to think are useful. And that's what, in some ways, Hana and I were trying to understand. And I'll just tell you, in our work at the Workplace Justice Lab, where we do this work with the agencies, we find great variation, and that's in part what Hana is asking about. It's there, right? It's out there. Why don't they, why do they do pieces? And I could go into great detail with you about like sort of why, just some more even finer grained stuff. But okay, the question about local labor investigators, I'll just say, whenever we talk about this stuff, it's like Pavlovian. People go, "Oh, street level bureaucrats." Right? Like every answer is Michael Lipsky. Now, I love Michael Lipsky. I studied with Michael Lipsky. I don't think street level bureaucrats in our story is the answer, honestly, because these agencies are very hierarchical in terms of the managers have a lot of power and they dictate a lot about what investigators do. Now, that's not true in all cases, and there are some investigators that are much more open to strategic enforcement and partnerships, deep partnerships with civil society. So we could talk more about that, but the investigators are managed very closely. And so we're really interested in how that happens and how that's shaped. Okay, motivations of employers to comply. We've thought a lot about that, and Hana and I have been involved in another project in Minneapolis that goes very deep on small business. And the test there is about, you can't find very small businesses into compliance. And so what are the other tools that are available? And what we are pushing for very intensively is to understand if you can help small businesses strengthen their systems, can you ratchet them into compliance? And we were, very informed by the Third Italy stuff, by this idea of ratcheting the compliance. So we're really looking at that. And we've spent almost 3 years now working on that. And, it will be no surprise to you, right, that a lot of these really small businesses, they just don't have capacity, right? But they're also advised in some cases by bookkeepers, and I don't worry about it. So we know we have to get to the social network of bookkeepers, right? They've turned out to be super important. The other thing is we've discovered electronic payroll systems don't guarantee compliance. They don't build in local minimum wages and other things. And what a huge policy intervention could be made around the rise of electronic payroll and requiring more around what they do. Okay. You asked about feedback loops, and yes, I mean, I want you to think about the fact that, for all intents and purposes, regulation at the federal level hasn't been able to keep up with the ways that capitalism is constantly morphing, as you pointed out, and hasn't kept up with the ways that the composition of the family and the ways in which women interact with the workforce, both as workers and also as consumers of childcare and home care and all that kind of stuff. So we think that the local and the state are responding to the fact that they can't get, the federal government has been stuck. All right, so yeah, so I'll leave it to Hana now.
I'll just say, just to turn it over, that there's clear feedback loops at the state level. So like paid sick leave started at the local level and then sort of built to the state level. So that's where we see the feedback loops. And then, yeah, all the symbolic resources is so tricky right now. Really important, and it linked to, you know, sanctuary cities very closely about kind of what does resistance look like. And I think we are going to wait and see how important that is in sort of, you know, protecting against, you know, all of the financial resource shortages that everyone will be facing. Okay, I'll turn it over to you all. Thanks.
Thank you. So I will say that officially our meeting ends at now. So whoever needs to leave, I totally understand. Whoever can stay, I know it's not all of you, we'll be happy to continue this conversation for maybe 10 more minutes just to hear some more comments and thoughts. I just want to say kind of quickly, I cannot, because of the time, I think we can't really address, you know, all of these questions. But first of all, Fabiola, thank you for these great questions. And I want to say something that I think maybe answers some of your questions about resources and about scale, and also the discussion happening now in the chat with Bashman and Desiree. And I think what perhaps I mean, the next step in thinking about at least our 6 building blocks is kind of taking it to where to kind of thinking about it together with the kind of project that Hana and Janice are doing, kind of bridging between our framework and the empirical setting, and asking whether and how localized enforcement in the context where it needs to be localized. Again, taking into account that what Janice and Hana started with, it's not like a bulletproof solution. It's just kind of the world we live in that leads us to these areas of enforcement. So how can this kind of enforcement grapple with the structural features of, in the context of global value chains, but not only domestic value chains as well, that are so problematic in many low-wage workers, working conditions, so subcontracting, tiered employment, lead from governance that characterize global supply chains and undercut enforcement in transnational settings. So I think it is a call for us. What we hear here, both from Fabiola and in the chat, is to reflect on whether enforcement innovations that, you know, the Janice championed in U.S. cities, strategic and co-enforcement participation of workers fulfills the same 6 enforcement functions our articles outlines for GVCs, especially when redress requires crossing contractual and organizational boundaries. So I take from all of this the question for us. I'm not giving you an answer. I'm kind of giving you the next step for where this conversation is taking me, is how might the 6 building blocks of enforcement developed for global value chains help evaluate or strengthen the effectiveness of local labor standards on the ground, whether municipal, local, state enforcement in contexts where employment is subcontracted, tiered, and connected to powerful lead firms. And specifically, can local administrative enforcement, what in the ILO language we call competent authorities, as Hana and Janice explore, generate meaningful redress and systemic deterrence when jurisdiction is bounded, but employer power is networked. So I'm kind of leaving this for me with a question. And I don't know, Shelley and Guy, if you want to jump in, or if maybe, you know, again, I'll say goodbye to those who have to leave, and thank you again to Janice and Hana, but also take some more questions if anybody wants to jump in and take 7 more minutes of your time for this. So if anybody wants to ask a question, please raise your hand. If Guy and Shelley want to jump in, please do.
I just wanted to respond. First of all, thanks so much, Fabiola. And on the resources, we must add we must deal with the resources. I think it's part of the 3rd or 4th building block of the independence of the agent or of the instrument. That's really important. And about the EU Labor Authority, I think they are mostly engaged with my impression, more engaged with proactive assessing EU mobility. Even when they have mediation, it's mediation between states and not between workers and employers. So I think, like everything EU, that is probably the most developed instrument that we have for transnational coordination. I'm not sure that this would be the right agency to look at, but clearly we do have examples from the EU that can be of help. So thanks about that.
Anyone
Yeah,
else?
a big thanks from me as well, Fabiola, for the comments.
Thanks to you for your work. Keep us thinking.
Any final questions? If not, I think we will call today. So thank you all very much. I will say that for those interested, Shelley and I kind of tried to bridge the local and the international, transnational in our article about Madhadi boards. I'm putting the link in the chat now for those who are trying to see how we did it there, how we tried to do it there, not exactly a perfect example, but one that we found useful. And I want to thank you all again very,
can we do
much.
self-promotion here for a second?
Of
Is
course.
that I think Shelley and Ingrid's work is brilliant, and I'm working in a different project on what's the meaning of a transnational collective agreement, which is an idea that we see in Shelley and Ingrid's proposal, and I'm trying to figure what could that mean. So it's kind of along the same avenue, and I think it's really, use the QR code. It's really an inspiring proposal to look at for many different ideas.
Thank you all very, very, very much. And I look forward to seeing you in our next meeting on June 12th. And I'll just say again that we also have weekly core group meetings, as you know, and I'm gonna put the time up again. And if you want to join us, please do. It's not friendly to North American friends. We will change it at some point, but now that's what we're working with. So I would love to see you there if you're ever in our time zone. And thank you again for all of our speakers, to Janice, Hana, Shelley, Guy, and Fabiola for taking the time to present this work for us. So thank you all very much, and I look forward to seeing you next time.
Thanks for organizing, Hila.
Thank you.
Thank you.
Bye, everybody.
Bye.
Thank you. Have a good day.